Hello everybody. Hello there. Ah, look at that. I said 5 common trial objections. Well, guess what? It's not 5 common trial objections. You want to know why? I'll show you why in just a second. It is, ta-da, 6 common trial objections. Yes, 6 common trial objections that you're going to learn about today, and I'm going to show you why they're so important. Here we go. 6 common trial objections, not 5. There we go, not 5, which is what I had here. Instead, we're going to do 6. 6, okay. Now, Andy, how are you? Nice to see you. We're not doing 5 common trial objections. We're doing 6. All right, everybody. Hello, how are you? Nice to see you. Welcome on a beautiful Sunday morning. All right, so today I want to share with you some really cool objections that come up during trial and tell you what they really mean. And I'll tell you why it's important for you to understand whether you are contemplating bringing a lawsuit or just for your own edification, for your own knowledge and understanding in learning what goes on when an attorney jumps up out of their seat and says, "Objection, Judge!" Whether it's on TV or whether it's in the movies and you're watching a courtroom drama. Oh, I love those likes. Keep coming with those likes. They're great. Excellent. Okay. So we hear about these objections all the time, right? We're watching Law & Order, and during the course of a trial, you hear an attorney jump up and say, "Objection, Judge!" Or we're watching a movie, let's say, whatever it is. My Cousin Vinny, for example. A great comedy. But I'm talking about trial objections. And why would an attorney make an objection? Thanks so much for the likes. Love it. Love it. Okay, why would an attorney make an objection? I'll tell you why. They make an objection because they don't like a number of things. The attorney might not like the question. The attorney might not like the way a question is phrased. The attorney might not want a particular piece of evidence being introduced to the jury. Hey, Carl, nice to see you. Welcome. Today we're talking about not 5 trial objections. Instead, we're talking about, if I can only get it now, we're talking about, here we go, 6 common trial objections. There we go. We're on the screen now. 6 common trial objections, right? It says, please stand by. Yes, you've already stood by. So now we're going to talk about 6 common trial objections. And I'm talking really about why an attorney, first, why would an attorney make an objection? Well, an attorney would make an objection primarily because they don't like something that's going on at trial. And you should know that an attorney actually has an obligation to stand up and voice his objection. You know why? Because if he loses the trial, and now he tries to appeal that particular issue. Now he tries to get an appeal and trying to get the case reversed. The court, the higher court that's going to be reviewing the issues below, they want to know, hey, listen, attorney, did you go ahead? Thanks so much for the thumbs up. Did you go ahead and object at the time that this improper thing was going on? And if the answer is no, then the higher court turns around and says, hey, you had an opportunity to raise that objection. You had an opportunity to alert the court that there's a problem, and you failed to do so, which means you waived your right to bring this issue up to us. That's a significant problem. Isn't that right? Yes, I love those thumbs up. That's a significant problem. That's why you will see that attorneys often will jump up out of the chair and say, "Objection, Judge!" They want to do that in order to preserve their right. David, nice to see you. Welcome. Welcome. Today we're talking about 6 common trial objections. At first, I started off by saying, you know what, let me talk about 5 common trial objections. And then I realized, you know what, no, we need 6. And I'm going to share with you exactly why you see them and exactly why an attorney would go ahead and raise these types of objections. So, in quick fashion, thank you so much. I love these hearts. I love these thumbs up. In quick fashion, one of the most common objections that we see is, "Objection, Judge, that's irrelevant." What does that mean? It's irrelevant. Okay, I'll give you a great example. Let's say this is a civil lawsuit, right, for an accident matter or medical malpractice or even wrongful death. And now the injured victim, not the injured victim or their surviving family members on the witness stand being questioned. And now, during cross-examination, the defense lawyer asks the injured victim or the surviving family member, "Hey, listen, how many times do you beat your wife?" What? What does that have to do with whether or not the careless driver caused this accident? What does that have to do with whether or not a doctor was careless in treating the patient? It has absolutely nothing to do with it. So the attorney has every right to jump up and say, objection, judge, that's irrelevant. And now what does the judge have to do? The judge has to decide whether or not the argument is correct. Is it really irrelevant? Is the question irrelevant? Is the potential answer that the witness is going to give unrelated to the issues in this case? And what are the issues? The issues are, was the driver careless? Was the doctor careless? Was somebody careless that caused this person harm and injury? Yes or no? Is it related to any of the defenses that are being raised by the people who are being sued here? If the answer is no, then guess what? These common trial objections come up. Objection, judge, that's irrelevant. So now the judge has to make a decision. He has to decide who's right and who's wrong. And he has two choices, really. Actually, three. But two choices, not one. He's got two choices. Either he says, yes, Mr. Attorney, I agree with you with this objection. It's a wrong question. It should not be asked. Or he says, no, I agree that the question should be asked. Legally, it's allowed to be asked. And now there are two ways that the judge is going to answer that question. He's either going to say, objection sustained, which means that the attorney who voices his objection and says, I think there's a problem here, Judge. When the judge says objection sustained, it means that the lawyer who asked the question cannot ask that. It also means that the witness who's on the witness stand is not to answer that question. I'm glad you're joining me. Thanks so much. Right? That's what objection sustained means. And now, what does objection overruled means? Hey, Craig, nice to see you. Welcome. Today we're talking about 6 common trial objections. Remember, guys, I started out by thinking I was going to talk about 5 common trial objections. And then I realized, you know what? There are 6 common trial objections that we see. Thanks so much for the thumbs up, Craig. 6 common trial objections that we see in these courtroom dramas, whether it's on TV, whether it's in the movies. Awesome. Love these thumbs up. And so what you have here, excellent. Love that. What you have here is the judge who now has to make a snap decision about an attorney who says something's wrong. And the judge could be right, and then again he could be wrong. But for something so obvious, where an attorney turns around and says, how many times do you beat your wife? That's got nothing to do with the issues in the case, with the claims being made, and the defenses that are raised. So in that instance, the judge in all likelihood is going to turn around and say, you know what? Objection sustained. Counsel, you cannot ask that question. Mr. Witness, you cannot answer that question. Move on to the next question. Okay? So that is one of the key objections that we see repeatedly in these types of cases. All right, so I've got my handy-dandy list here. That was one. The second common objection that we see typically is, objection, Your Honor, that's hearsay. Now, what is that? What is hearsay? I hear him say something. No, that's not what it means. Hearsay is something very interesting. All right, so let's take an example. It's a medical malpractice case, and now you are the injured patient. You have sued your doctor claiming that your doctor violated the basic standards of medical care, and now you suffered significant harm and injury. Well, guess what? You're on the witness stand now after 3 long years waiting to get to trial. The defense lawyer is now cross-examining you. And now what does he do? He says, hey, Mr. Jones, tell me what you and your attorney talked about before you ever came into court. Or he'll turn around and say, hey, what did you talk about with this other person who's not in court? And now you begin to answer the question, and guess what? That's a problem. Why is that a problem? No, let me change the example a little bit. So let's say it's your lawyer who's asking you questions, right? And you want to get out information about a conversation that you had with a doctor in the hospital. You want to tell the jury, you want to tell the judge that a doctor in the hospital doctor in the hospital told you something about the care and treatment that your loved one or that you were receiving, and that it was improper. Hey, that doctor, whatever he did something wrong, and you should go ahead and speak to a lawyer about that. Okay? Now you want to get that information out to justify and bolster your claim that, what? That there was something done wrong in the hospital. So now you want to tell the jury about this conversation that you had with this doctor who's really treating you and knows the inside scoop about what was going on. So what does he do? Now your attorney asks the question, hey, Mr. Jones, did you have a conversation with Dr. Gonzalez? Yes, I did. Tell us what happened. What did Dr. Gonzalez say? Now the defense lawyer jumps up and says, objection, Judge, that's hearsay. Really? What does that mean? What does hearsay mean? I'll tell you what it means. It means Dr. Gonzalez is not a party to this lawsuit. Dr. Gonzalez, this doctor whom he had a conversation with, whom you had a conversation with, is not in court. No one had ever had an opportunity to question Dr. Gonzalez to see what it was that he claims this patient said, to see whether or not the patient is saying something truthful. No one ever had an opportunity to talk to this doctor. So now for the very first time, the defense lawyer learns that here's a guy who said something that could be damaging to his client's case. Could be damaging. So now, you, the injured patient, want to go ahead and tell the jury about this conversation. So you start to tell him, and guess what? He jumps up and says, "Judge, that's hearsay." And what it really means is, the lawyer doesn't want this witness, you, the injured patient, to talk about the conversation because he has no way to verify whether or not the claims that you are talking about are in fact true. And since this witness is not in trial, let me change that. Since this person who you had the conversation with is not in court and is not expected to testify, how can you test the credibility of that particular person? And because of that, now, if that's true, if this person is unrelated to the lawsuit and has no legal obligation to come in and testify, and no one has called him to testify, then anything that you are about to say is considered hearsay, which means you are not permitted to tell the jury about that. That's a fascinating objection that comes up over and over and over again. You, the injured patient, believe that you can go ahead and talk and tell people about your conversations. You can't. If they are not part of the lawsuit, if they are not people that you sued, you cannot say what somebody else told you because they're not in court to verify and be cross-examined. That's objection number 2. Now, what happens with objection number 3? Let's find out the next most common objection that we see. All right, here's one. We talked about being irrelevant. We talked about hearsay. And now, what do we want to talk about? We're going to talk about an improperly worded question. It happens all the time in every type of case. So now, an attorney is questioning a witness, and he just gets his words jumbled. And now it just comes out so ridiculous that the defense lawyer has no other opportunity but to jump up and say, "Objection, Judge, that's an improperly worded question." What happens then? Does the judge say, "Hey, you can't ask that type of question"? Or does he simply say, "Counselor, rephrase it"? That's what's going to happen. He's going to tell the attorney to simply rephrase the question. And by the way, you will find that some of the best trial attorneys, at least in New York, are able to reword questions, not 5 different ways, not 10 different ways, 15 different ways or more. So if an attorney makes an objection about how his question is phrased, now all of a sudden he says, "Okay, Judge, no problem. Let me ask it this way. Hey, Mr. Jones, isn't it true that you did this, this, and this?" And then he'll ask it a different way if he gets another objection, and another way, and another way. "Hey, Craig, thank you so much. You too, have a great Sunday." So it is so important for an attorney to understand how to rephrase and how to remodel a question if you get an objection saying, "Judge, that's worded improperly." You know, when you talk to somebody, all of a sudden you're thinking, and sometimes you try and talk first before you think through the entire question. That happens to lawyers all the time. Most really good attorneys do not have prepared questions. Instead, they have outlines of information that they're trying to find out, and now they have to think on their feet. And if they're thinking on their feet, at the same time thinking about something else, thinking about a piece of evidence, thinking about something that happened 5 minutes ago, their question is going to get jumbled. So, you know what happens then? They come out with a question that's totally bizarre and doesn't really make sense. And now somebody turns around and says, "Hey, counselor, your question's improperly phrased. Please rephrase it." Okay, I'll rephrase it. You will find that some novice attorneys, some really inexperienced attorneys, they fight with the attorney and they fight with the judge about the wording of their question. Why would they do that? They do that because they don't truly understand how to phrase a question properly and how they can change up the question many, many different ways without having to fight over the stupid thing. And here's how it comes up. The defense lawyers, if I make an objection during trial or even during pretrial testimony, known as a deposition, I'll say, "Objection, counselor, that's an improperly worded question." And a novice attorney will turn around and say, "What's wrong with my question? I'm allowed to ask that question. I'm entitled to an answer to my question. You're going to answer my question." Well, that's fine, but not in the way that you phrased it. Phrase it a different way, and he'll be happy to answer the question. So this comes up in every single case, either in pretrial testimony or during trial. All right, it's time for a quick water break. And remember, here we go. Remember what we're talking about here. We're talking about 6 common trial objections. So now I should have a piece of paper here for water break. And I don't have a sponsor, but I am drinking Poland Spring water. But if you'd like to sponsor this, give me a call. Reach out to me. I'll be happy to chat with you. How do you like that? Instead of the lower third, you know, that you see on all the news channels coming by, here we just have a piece of paper drifting by. You got to have fun doing this, right? Otherwise, what's the point? All right. Thank you so much for the thumbs up, and also my improvised lower third ticker that comes by. Yeah, it's a beautiful day today here in Great Neck. Thank you so much. I love that. That's great. So it's a gorgeous day today here, and I'm shooting the video outdoors, and I just wanted to give you an idea about the 6, not 5, the 6 most common trial objections. See, I started out with 5, then I realized, you know what, there are 6 most common trial objections. So let me get my notebook, and we're going to pick up where I left off. All right, here's my handy-dandy trusty notebook, and let's see what the next one is. Here's a good one. All right, so now we're at trial. An attorney asks a question that has 2 questions contained in it. Hey, Mr. Jones, isn't it true that you were speeding while you were playing on your phone? That's known as a compound question. He's asking for 2 answers contained within one single question. If the witness says yes, is it yes to he was speeding, or is it yes to he was texting on his phone? Which one is it? The problem is you don't know. So the attorney who objects to that question would be absolutely correct to argue and say, "Objection, Judge, that's a compound question. He needs to rephrase it." And the judge would say, "Objection sustained. You're absolutely right, counselor. Defense attorney, please rephrase your question." What does that mean? It means he's asked an inartful question. He knows he's going to get the information that he asked, right? He needs information. Now, he wants to know whether or not this person was speeding. So, again, it's not a great way to ask it to come right out and say, "Hey, were you speeding?" Because the obvious answer is no, I wasn't speeding, right? So you don't really ask that question, but just to give you as an example, yes, even trial lawyers have difficulty getting their words out. You don't want to ask 2 questions within one, because when the answer is given, where he says yes or no, you don't know whether it's the first part, the second part, or to both, or to none. So you have to break it apart. Hey, Mr. Jones, were you speeding at this time? No, I wasn't. Mr. Jones, were you texting at this time? No, I wasn't. You ask one question, get one answer. That's the ideal. That's exactly what you want to do. So, compound questions are crucial to object to. Now, another reason why an attorney objects is because if you don't object at this point in time, here's what happens. So now the witness goes ahead and says no, and we don't know exactly what he answered no to. And now if the lawyer loses the case and now has to appeal it again, the only thing that the higher court looks at is the trial transcript. They want to see what was asked, and they want to see what was answered. They want to see if there were any legal errors made. And what do they look at? In this particular instance, they're looking at a compound question. Mr. Jones, were you speeding? And were you texting? That's it, I remembered. Okay, were you speeding? Were you texting? If he says no, the higher court looks at it, and they're also wondering, what did he say no to? To the speeding? To the texting? To both? To none? They don't know either. So you create a problem for the higher court if you have to appeal that issue. So that's why it's very critical for the attorney to jump up out of his seat and say, "Objection, Judge, that's a compound question." And it takes 2 seconds to simply rephrase it. Hey, Mr. Jones, were you speeding? No. Were you texting at the time? No. There you go. You now solve that problem. All right, let's go on. We've now covered 4 common trial objections. Now we're going on. Hang on. Now we're going on to number 5. All right. This is a good one, and I need a prop for this one. Hang on. Here we go. It's my trusty handy-dandy mini bat, right? The one that you get going to a baseball game, you know, on a free day giveaway. Now I'm asking questions of the witness during cross-examination, and the witness is not being helpful. The witness is being obstructionist. He's now giving me a problem. He's arguing about semantics and word issues. He's now playing games with me. Doctor, isn't it true? Isn't it true that it's critical for you to keep accurate records? Well, I don't know what you mean by accurate records. Doctor, isn't it true that it's important for you as a physician to keep thorough records? Well, I don't know about thorough. I wouldn't argue about Doctor, isn't it true you need to keep detailed records of your patient? Well, it depends how you define detail. So now he's arguing with me. And now I'm hammering home over and over and over the fact that his records need to be accurate, they need to be thorough and detailed. And now the defense attorney jumps up out of his seat and says, Judge, he's badgering my witness. Really? Now, at trial, I don't really have a bat, and I'm not hitting anybody over the head at trial, although I probably would like to, because this guy is being such a pain in the ass, right? That's the frustration that a lot of attorneys get when there's a witness who's being uncooperative or a witness who is playing mind games and word games so that he thinks he's smarter than the attorney, and he thinks by playing word games he's going to come out looking like a rose or looking great in front of the jury. But the reality is, no, that's not going to happen. Instead, you look like a pain in the ass who's fighting over little semantic words. Now, although words do matter, and it's critical as an attorney, words do matter. But to argue with me about whether or not it's appropriate for a doctor to keep accurate records, or thorough records, or detailed records, now you're just being a pain in the ass, and that's going to force me, most likely going to compel me, to go ahead and hammer away 1, 2, 3, over and over and over again at you for being such a pain in the neck. Right? If you simply said, yes, it's important to have accurate records. Yes, it's important to have detailed records. Yes, it's important to have thorough records. Okay? You've just agreed. It's something that's obvious. Everybody knows that. But now, what am I doing? Now I have no choice but to let the jury know that you're being a pain in the ass. And I'm not doing it with a bat. This is a metaphorical, right? A metaphor, right? Even though I've got it in my hands as a prop, it's not something that goes on at trial. But the defense attorney has every right to turn around and say, hey, Michael, nice to see you. Okay? In case you don't know, hang on one second, Michael. Today, we are talking about what I thought was 5 common trial objections. And then I realized, you know what? No. There are actually 6 that I wanted to talk about. 6 common trial objections. So now we're actually on the 5th one. The first one that we talked about was something that was irrelevant. The second we talked about was hearsay. We then talked about an improperly phrased question. We talked about a compound question. And now we're talking about badgering the damn witness, a witness who's not agreeing with us. Ugh, you get so frustrated. So now I take my little mini bat and I want to start hitting him over the head. Yeah, I know. Can you believe that? That's great. But the reality is I can't take this into court and start hitting anybody. I'll be arrested for assault. Nobody wants that to happen. But this is simply a metaphor for badgering the witness. Yeah, excellent, Ben. Nice to see you. So what I was saying was, this is the metaphor, and the defense attorney would be absolutely correct to jump up out of his seat and say, Your Honor, Mr. Oginski's badgering my witness. And what do you think the judge is going to say? If I'm being so aggressive, if I'm being so nasty and going after this guy because he's not being cooperative, he's going to say, Counselor, objection sustained, which means, and you know it already, right? Which means, hey, you can't answer that question. You've got to rephrase it, move on to something else, do something different. Badgering the witness is not appropriate. And, by the way, if I keep this up, if I keep doing this, you know what's going to happen? The jury is going to wonder in their own minds, why am I beating up on this guy? Why am I hitting him over the head repeatedly when he's trying to answer my questions? They may not truly understand, and I may not have communicated well, the fact that my frustration is now coming out because the doctor is not answering the questions the way that I want him to answer the questions. So there are different strategies that I can use that I'll save for another day to show you how to control a witness on cross-examination that is so effective that the witness has no choice but to answer my questions the way I want him to answer them. Now, that's very powerful. All right, so I'm going to take another quick water break. Don't go away, because we're getting close to The sixth common trial objection, and now let me just grab a non-sponsored water break from Poland Spring, even though they did not sponsor this. And at the same time, we have the improvised ticker that's going across telling you what this video is about. I love it. Let's see CNN do this. Let's see their anchors stand up in front of you and go like this repeatedly, holding a piece of paper instead of having it on the lower third, right? That would be great. I'd love to see that. Okay, so now, we have now come to the sixth and final trial objection that we see commonly in these civil lawsuits here in New York and throughout the country. Okay, the sixth one is, you know what it is? I'm going to show you exactly what it is. The defense attorney during cross-examination asks, no, the defense attorney is asking his own witness a question. And now I get up and I jump up and I say, Judge, objection, he's leading the witness. The sixth objection is leading. Judge, I object, he's leading. Now what does that mean, leading the witness? Okay, I'll tell you. There are two types of questions that an attorney can ask a witness. And it depends on whether or not the witness is your witness or he's being cross-examined by the opposing witness. So, if I am asking my client, the injured patient, questions on the witness stand, that's known legally as a direct examination. My goal is to ask open-ended questions. Who, what, where, when, how, why. I want my client to go ahead and explain away. Go ahead, Mr. Jones, tell the jury why this happened. Tell the jury what you did. What happened next? What did you do next? What did they do next? What did you see? What did you hear? What did you learn? That's an opportunity for the witness to go ahead and explain, right? So that's known as direct examination. If I am questioning a witness, now I'm cross-examining a witness. Let's say the defense brings on a medical expert, and now to oppose all of our claims. And now I get up to question the witness. I want to ask leading questions of this witness. I don't ever want this witness to go ahead and explain anything. Instead, I need the witness to answer just my questions. Either yes, no, I don't know, or I can't answer. And there are different strategies to get that witness to do it. So now, it is totally appropriate for me to ask an opposing witness who I'm cross-examining leading questions. Dr. Jones, isn't it true that you evaluated this patient on this day? Yes. Isn't it true that you recommended surgery on this day? Yes. Isn't it true that the surgery you recommended was to have surgery on the right side of the brain? Yes. And tell me, Dr. Jones, isn't it true that on a week later when you actually went in for surgery, you operated on the left side of the brain? Yes. What have I done? I'm now making statements, and I'm getting the doctor to either agree or disagree. That's all I want on cross-examination. And now I'm asking him specific questions. I don't want him to explain anything. He's spent hours already explaining lots of things in response to his lawyer's questions on direct exam. So now I'm entitled and I'm permitted to ask leading questions. And if the defense lawyer were to stand up and say, objection, that's a leading question, what do you think the judge is going to say? The judge is going to say, objection, overruled, counselor. This is cross-examination. Mr. Oginski has every right to ask leading questions, right? And that's absolutely true. But now let's turn it around. Let's say I'm putting my expert, my medical expert on the witness stand. My medical expert. And now I'm asking my medical expert questions because I want to get certain information out to the jury. Hey, Dr. Gold, you reviewed records on my behalf, isn't that true? Yes. I asked you to review this patient's case, isn't that true? Yes. Now what am I doing? I'm the one who's making the statements, simply asking from my witness yes or no questions. Well, I'm allowed a little bit of leeway to do that. Doctor, isn't it true that you and I met before coming into court? Yes, it is. And isn't it true that you and I spoke about this case before you actually agreed to come into court? Yes. And during the course of our conversation, you told me that my client had a good case, isn't that right? Objection, leading question. Isn't that true? Is that a leading question? The answer is, yes, it is. Can I ask that? Well, I can ask it, but in all likelihood, the judge is going to turn around and say, hey, Mr. Oginski, this is your own witness. What are you doing asking leading questions? Judge, this is just a preliminary matter. I need to give the jury some focus, some context about why this expert is here. So the judge will give me a little bit of leeway to ask leading questions. But now, if I were to turn around and say, hey, Dr. Gold, isn't it true that based upon your expert review, you determined that this doctor, Dr. Jones, violated the basic standards of medical care? Objection, leading question. Yes, it is. That is leading, and I would not be allowed to answer that. No, not answer that. I would not be allowed to ask that. So instead, I have to ask a different question. Hey, Dr. Jones, as a result of your review, did you come to certain conclusions? Yes, I did. And what were your conclusions, doctor? Oh, it was my conclusion that Dr. Jones violated the basic standards of medical care. Notice the difference? Rather than me asking the question, I ask an open-ended question. And now the doctor can go ahead and explain. If I were to simply put words in the doctor's mouth, that calls for an objection, which is leading. Hey, he's leading the witness, and that is true. So for my own witnesses, I don't want to lead them too much. It's something you don't want to do. Otherwise, you're going to get that objection where the attorney jumps up and says, objection, judge, he's leading the witness, right? So you don't want to get that. So now, what have we covered? We have covered exactly what I said we would cover during the course of this video. 6 common trial objections. Please stand by, right? So now we got the ticker. There we go. There we go. So during the course of this video, hopefully you have learned 6 common trial objections. And why is it important for you? It's important because if you are a litigant or contemplating bringing a lawsuit, especially here in New York, you need to know what's going to happen or what is likely going to happen when you go into court and are now sitting in the courtroom watching the proceedings. And the next time you watch a courtroom drama on TV or you see a courtroom show involving, courtroom highlights in either the news or in the movies, you're going to know exactly what the 6 common trial objections are and what they really mean, because nobody tells you what these mean. And what are they again? Let's go through the list very quickly, because we're going to cover quickly 6 common trial objections. The ones I covered are objection, that's irrelevant. Objection, that's hearsay. Objection, that's a compound question. No, that was number 4. Objection, that question is improperly worded. Number 4 was objection, that's a compound question. Number 5 was, let me get my prop. He's badgering the witness. Yes, yes, yes. Okay, he's badgering the witness. And number 6 was objection, hearsay. I realize you're watching this video because it came up on your Facebook feed early this Sunday morning. And I hope if you've been watching it, you've actually enjoyed it. I hope it's been entertaining. I hope it's been interesting. And I hope that you learned something about objections during the course of trial. And if you're watching this on the replay, in all likelihood, chances are you are searching for information about how your particular type of case works. Well, thank you so much for those likes. I love it, love it, love it. Yes, yes, that's great. Yes, an explosion of likes. That is awesome. Absolutely awesome. I really, really enjoy that, and thank you so much. I appreciate you being here and giving me those wonderful thumbs up. Thumbs up? Yeah, that's it. So, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions, don't worry, I'm not going to sit and badger you over and over with this little mini bat. Instead, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I answer questions just like yours every single day, and you can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video on a beautiful Sunday morning. I hope you have a wonderful and fantastic day. Take care, everybody. Bye-bye.